Hello everyone, welcome to my channel DIY Law. Please go ahead and subscribe. If this topic is of interest to you, please check out my other videos on this channel as well. Before we get started, just a quick disclaimer, I am not a lawyer. The contents of this video is not legal advice. It's intended for information and educational purposes only. The name of today's video is Get Your Evidence Admitted, so let's get started. Folks, don't wait until trial to present evidence. There is no evidence you can get admitted at trial that you cannot get admitted before trial, so why wait? Foolish people wait until the trial to present what they think is evidence, documents, things, and testimony. They show up for trial, thinking they can get evidence they need into the record during the trial, only to have it thrown out at the last minute as inadmissible. If your evidence is excluded at trial, there's no way to get it in later. There is no later when it comes to presenting evidence. Folks, the trial is the end of the road. You cannot present evidence on appeal if it wasn't presented during the trial phase in the lower court. So, never wait to present your evidence for the first time on the day of the trial. That is a big mistake. Nothing you may think is evidence is worth a fiddler's fig unless it gets into the court record as admissible evidence, and trial is not the time to try to get evidence admitted for the first time. So why lose needlessly? Don't try to be tricky and surprise your opponents at the last moment. You cannot win by ambush in court. Don't hide your evidence, waiting till the last minute to spring it on your opponent at trial, hoping your opponent will be surprised and not be able to respond effectively. That's a bad idea. Ambush doesn't work at trial no matter what you see on TV. If you don't get your evidence in before trial, you likely not get it in at all. Then you lose needlessly. You only get one bite at the trial apple. Never trust that a document will be admitted, even if it's sealed with royal wax imprinted by a king's ring and raked with silk ribbons. If you assume you have evidence to spring on your opponent at trial, you are playing a dangerous game, risking everything for no advantage whatsoever. Evidence that isn't admitted isn't evidence. Authenticate your evidence and use your pre-trial evidence tools to get it in as early as possible. The tactical power of this legal self-help training course called Jurisdictionary will show you how. Look, it's just a fact, too many good people lose just because they can't afford a lawyer. The Jurisdictionary course will teach you how to challenge judges, how to write proper pleadings, how to get evidence into the record, how to properly move the court, how to make courtroom objections, and much more, so go ahead and represent yourself. There is help now. Since 1997, Jurisdictionary has helped thousands win without a lawyer. It's easy to learn, you will learn quickly, in as little as 24 hours. You'll know how to win. Link to the course is in the description below. Take the free test and discover your legal skill level. It's fun, and the results may surprise you, and while you are there, take a look at the testimonials and success stories from people just like you. In conclusion, why not learn how to represent yourself? Even if you do hire a lawyer, the Jurisdictionary course training will help you understand what your lawyer is doing or not doing to help or hinder your case. Folks, justice should be for all, not just the rich who can afford lawyers. Jurisdictionary is justice for all. Again, link is in the description below, and yes, this is a plug for the course, and yes, I get a small commission if you sign up. So check it out or don't, it's up to you, it's your case. Thanks for watching, please go ahead and subscribe, hit the notification bell and leave a comment below if you wish. Thanks again and best of luck in all your pro se legal matters.